Oh, there we go. Okay. All right, welcome. Let's go ahead and get started with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I have asked Commissioner Helgeson to give a thought or legislative prayer tonight, so I'll turn the time over to her.
Well, I don't have much of a thought, but I've been working at the Board of Education this last few months, and I have been in some different committee meetings and board meetings, and just been very impressed with some people and their passion to make things better, to solve problems, and I just, as I've thought of that, I just thought, you know, it's a privilege to be involved wherever we are in service of our community, and so to be a member of the Planning Commission, it's a privilege and an honor, and I appreciate the ability that we have in our country to do such things, and so just wanted to share that. I think that it's an important thing to do wherever you do it. So this is where we are right now. I'll say a quick prayer. Our Father in heaven, we are grateful for the opportunity to be here as Planning Commission members and staff, and we're grateful for the opportunity that we have to serve. We pray that Thou wilt bless us with wisdom as we contemplate the things for our city, that we will search for things for the overall good and not just our opinions, but to have open minds and hearts and try to serve those that are in our community. We pray Thy Spirit here tonight and say this in the name of Thy Son, Jesus Christ. Amen.
Thank you very much. First item on the agenda is a zoning text amendment that's been tabled at the request of the applicant, so that one will be coming back to us on September 12th. So we'll move to the next item on the agenda, which is a discussion of subdivision ordinance updates. These are always very exciting. We really like digging in and improving our ordinances. So I'll go ahead and turn the time over to Lisa.
Great, thank you. This is Chapter 2 of our subdivision rewrite. And Chapter 2 deals with definitions and some basic rules of interpretation. These are similar to the Chapter 2 that we have in our zoning code. It's just definitions that we want to set some parameters. I realize that, well, this set of definitions are not as long as the ones in our zoning code. They still seem long. It's 13 pages. But this is a work in progress. I wanted to give it to you so I could get some early feedback. But there's a couple things that I've put in a number of the definitions that are in the state code that we use in our own code. Now, what you can do in drafting, and they do this in the Utah code a lot, is they say, go see Title 2, 3, 501 where this is defined. So I could easily say, you know, any term used in our subdivision ordinance that's defined in state code, go see it. But people don't really have easy access to the state code. So I have generally put those state code definitions in here to help, you know, staff or citizens or, you know, even me. Then I don't have to go look up the state code definition. Now, that means that we need to keep on top of it because the state code definitions might be amended, but I think we do a good job with that. We go through the legislative amendments each year. The league keeps us apprised of those, and so if they make changes to those definitions, you know, it's just a burden that I'm willing to take. But so I think it's helpful. If you wanted to cut down your definitions, you could easily just say, go see this state code definition, but I don't think it provides a useful tool for many people because they're just going to go to that definition and be frustrated because it's not there. So just to give you, and I think in this version, I went ahead and highlighted all the terms that are in the state code. And those terms have been, excuse me, updated through the 2018 legislative session. So we still had to make some tweaks because the consultant drafted this in 2016, so this includes 2 years worth of legislative updates and some tweaks. I can't remember at this point which ones, but they've made some changes on the term of administrative and legislative decisions, so those are included here. Another thing we struggled with was, like, in our zoning code, we say street, comma, half street. So when you get to street, all the streets are there. But you have to know, like, if you're looking for half street, you need to know, go to streets. So what we put in here, which also makes it a little longer, but I think more user-friendly, for instance, on alley, we say, look at the definition under streets. Because I think, you know, there's a few of those where we've made some cross-references, because I've found even using it, I'm like, oh, half street's not defined. And oh, yes, it is. It's just under streets, comma, half, or something like that. So that makes it a little longer, but more user-friendly. We could also take those out now that we would have a completely searchable, you know, PDF. It made it harder when, or online, when we just had the PDF and you couldn't search as much. But and then the third thought that I wanted to mention is that we need, once we finish our title, the final thing on definitions is to do a search, but this is good. Once we put it on MCO, I can search, and I will search every single term and make sure that it's actually used. So we did find in the zoning code that there were some definitions that we don't even use anymore, so let's, you know, take those out. So I will do that, like if you're saying, oh, do we even use that? Ask me at the end. We will do that analysis. And then also make sure as we're using them that we're satisfied with the definition. So this is really preliminary, and we do need to do some more work at the end to make sure that all the terms we're using are used and that we like the definition. But, you know, on a lot of things, it comes down to the definition. So it is an important chapter. And a lot of times when we're using things, you know, you're reading a section and you say, oh, I better see if this is a defined term. So with that, if you have some specific questions or any corrections that I need to make, that would be great. And just bear with me, I didn't print out this last version that I gave to you, so, but if you just give me the section and then the subsection number, I can get there.
Thank you very much, Lisa. With regards to incorporating the definitions that are defined by Utah State Code, are they primarily found in one specific code section, or are these the definitions in a number of different code provisions?
Most of them are in one section, 10, 9A, 103.
I mean, I guess my one thought is, as a practitioner, I certainly like to have all of these definitions listed. From ease standpoint, it's great to have all of the defined terms that I need to worry about in this particular code in this section. But if the state does change it, there could be some, and even if we stay super on top of amending these things, that could leave a period of time when the statute and the code in our ordinance is different. So I'm wondering if we could incorporate maybe just a catch-all in this to say at the end, to the extent that any of the definitions are inconsistent with the state code trumps. I don't know if we can do that in an ordinance. I was thinking it would be easy if we were pulling them all out of one state code section. If we're gonna have to list a number of different code sections, maybe that is not such a useful idea.
Let's see.
Well, you could list a reference to that state code for each of these ones
Yeah.
that's highlighted, right? So
Well,
that,
Or you could even just list a reference at the very beginning and say, these definitions are provided for your convenience. However, like similar wording to what you said, you know, however, if it is not congruent with state code, please rely on current state code
I don't feel
language or
strongly.
something like that.
I don't feel strongly about it because I think that any changes that are going to be made are most likely not going to be incredibly substantive, and if they are, that they'll hit our radar and we can amend them. I'm just thinking for purposes of maybe filling in any gap.
Yeah, I think that you could do it. I probably wouldn't say these are as a convenience because we are defining them.
Okay.
So we are adopting them as a definition, but
Okay.
I think we could craft some language in the beginning saying a number of these definitions are defined in
Yeah.
10(9A) 103, and if there's any conflict with those state code definitions, the state code definition will govern. I think we already, first of all, we already do that as practice, and second, we probably already have a conflicting provision in chapter 1, where we said if anything in here conflicts with state law, the
Okay.
state law is going to govern. But for instance, I know our definition of family, I think in our zoning code, we haven't fixed that, and it's in conflict with state law. And my advice to staff has been, we need to go with state law because we're out of compliance with state law. So as a matter of practice and provision, but I still think it's a good idea just where we're putting the definitions. I'd rather do that and leave the definitions in, because again, I just think, I hear the complaints of people, yeah, now, and then they call me and say, Lisa, can you get me this state code provision, you know, which is fine, but, so yeah, I can certainly add that. I think that's actually a good idea.
We'll do it the same way that you, at the end with illustrations, the very last sentence, if conflict arises between an illustration or a figure and a definition, the definition shall apply, right? So
Yeah. Yeah, good.
I have a couple other things.
do we want to go page by page?
Yeah,
through
let's
this
do
maybe?
page by page. That sounds fine.
Mine
Unless
is-
there's concept stuff.
Mine is just a concept of when you are using a numbering system or an A-B system, and if there's multiple ors, you've generally just used, you've listed like 1, 2, 3, or 4, and I think, I don't know if it, I mean, if it was in a sentence, that would make sense, but I'm not sure. Maybe you want to put or after each paragraph, 1 or something, or.
Usually I don't, and I guess I could see, I try to stay consistent with what the state code does as well, which is dun, 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 and, you know, so we always know you just go to the end and see if it's an and or an or.
Okay.
So that would be my preference, but.
If that's how state code does it, that's great. Then that would be my thing. And specifically, there was a question on the subdivision section, but if it's already treated that way, then that's okay. The only thing is with 1. Okay, so that means like for subdivision, for example, you read all the way down to 6, and it finally, so page 12 of 13. So you've got A, 1 and 2, and then B does not include, and you've
Oh,
got
and those
1, 2, AB 3, AB 4, AB 5, 6, or 7. So then you have to go back and think, okay, I don't, just to me it seems,
Yeah.
but I guess if
Well,
that's
and
how
look,
they do it.
in the first subdivider, they do use or every time, so I still would rather not. But again, it might just be inconsistencies that were pulled straight out of state code. If it's a state code definition, sometimes they are not always consistent. But I'll double check on that and be consistent throughout.
How they're, yeah, either way.
Okay.
Thanks.
Okay,
I actually kind of agree with that, just because if there's ands for some and there's nothing for some, it leaves it to our imagination if it's and or.
I would agree with Lisa on this, just because I'm so used to, from a legal standpoint, having a number drafted and looking for the last thing. I think that it,
Yeah, well, it's just like a sentence. You say
Right. That's what I'm
apples,
saying, as a
bananas,
sentence.
carrots,
It
and
makes sense as a sentence, but I just wasn't sure if that's, I guess if it's legal, common legal practice to do it that way, then I think it's fine.
but these, I do agree, these definitions
still-
that come
it's
from the
still
state
hard.
where they do so many subparagraphs, it gets ridiculous,
Yeah.
so I agree.
reminds me of those math problems where you have to do the middle parts all first, right, before you can put it all together into one math sentence. But that, I guess, is what it is. Okay, any other comments sort of on a global basis before we just start marching through page by page?
Yeah, Lisa, I don't know if this is possible. Sometimes it's hard to know what items are defined and what aren't as you read through the ordinance, you know? I don't know if there's like a technique or a way that we could identify that anything that was defined gets like underlined or something like that.
Well, some codes, if it's a defined term, they will capitalize them.
Okay.
But it looks kind of awkward if you're just reading
Something about this chapter.
and then you're
Suddenly
like
it's screaming
capitalized,
at you.
because not everybody knows that term.
Yeah, okay.
We could get, I don't know, the program does have the ability to hyperlink. And I know we've talked about, can we hyperlink any state statute, or even cross-reference? And in talking with them, you know, initially we would prefer not to, because then we have to keep all those hyperlinks. First of all, you have to keep the link static and make sure somebody doesn't move what you're linking to, and, you know,
Yeah.
somebody has to keep track of all of them. So I don't really want to, I definitely would push back on hyperlinking every internal code cross-reference, because there's hundreds of them in our code. But defined terms, you know, we could think about that. But I still think it's going to make your code look a little.
Are you talking about like all capitalized, the entire word capitalized?
No,
or
they
the
just
first?
capitalize. So for instance, in drafting an agreement, we'll put it in parens and say, you know, parties. And then whenever we use parties again, we capitalize it.
Right.
Because now it's a defined term.
Right.
But in codes, I've seen it both ways, but it's sort of awkward with
Yeah,
the
I mean, if you
capital.
read subdivision every time in the subdivision ordinance.
Exactly, you're gonna be like, up, down, up, down. So I would say no, and same thing with the underlying. You just have to realize, hey, anything in here could be a defined term, we need to double check. But most people, you know, I mean.
The good news about technology, at least as a practitioner, when I have when I come across a word and I'm not sure whether it's defined or not, you can go search the entire code for that term, right? And
True.
it pops up everywhere it comes in. And so I think that given the technological capability that we have now and that we're going to be putting it on our website, I would be comfortable just
It's going to be a
leaving
lot
it,
more
yeah,
expensive.
as
You're
is.
right. All they would have to do is put that right in the heading. And that's why,
Right.
for instance, we cross-reference, because if you searched half streets, half dash street may not come up because you've defined it as street comma half. So I've tried to, you know, put at least half street and then go see this, and then you get there. But yeah.
Okay, any other questions or comments before we start going through page by page? All right, let's go ahead and start with page 1. Page 2. Page 3. Page 4.
I have one on page 4. Flood 100-year and flood 10-year. Basically just say that there are floods that have 1% chance and a 10% chance of occurring. The next one, floodplain, tells us that it's, you know, land within the 100-year floodplain as designated by FEMA, or does something else designated by FEMA. So part of my thought there is, are we 10 and 100-year, are those FEMA floodplains, and should we say as designated by FEMA, or somebody else deciding what that is?
So the floodplain is a statutory definition, and you definitely want to know where the floodplain is. It's on those FEMA maps. The city engineer actually recommended, because I think we had one of these definitions. Oh yeah, we had the definition of flood, 100 year. So because we reference it in this FEMA definition, and he wanted to add flood 10 year because some of our design constructions has to be designed to a 10-year flood event, and some design construction has to be built to a 100-year flood. So this might be familiar to Gina. But so the city engineer was saying, I recommend, you know, we add in these two different definitions. So I don't know if those are FEMA definitions or where they come from. I can double check on that.
Well, I bring that up just to try and avoid the potential of somebody saying, well, 10% according to who, right? Is it a 10% chance of a flood according to FEMA, a 10% chance of flood according to?
I think it's just historical
according to history.
Yeah, it has nothing to do necessarily with FEMA. It's a historical, how often does that size of a flood occur?
So it does say that statistically has a 10% chance. So I guess we look back at the statistics and perhaps
Right.
there's an engineering standard of how we do that statistical analysis.
Okay. Well, I'm not saying that, well, anyway. I was just thinking about it in terms of interpreting it differently depending on the parties involved, right? So the city says, yeah, you need to do this according to a 10-year flood standard, and maybe the developer decides, oh, it's not gonna, it's not 10-year flood, this is looking back historically, or whatever they want to decide to do. They're like, no, this is more like a 100-year flood.
Okay.
And then we're disagreeing about what it is or what it
Yeah.
isn't, right?
Well, that's good. I'm happy to ask the city engineer, so the basic question is 1 or 10% according to,
According to who?
yeah.
Well, and according to what, I'm totally with you now on this, because I could have a developer that looks back only over the last 50 years, and the city could be looking back over the last 500 years, right? And that could very well change whether it's a 10, what the percentage is. I think that's a good clarification.
Yeah.
Do you know, Corey, or?
These are off of the FEMA. They do a statistical climate data, and these are the statistics that they use.
So, or we could just say, according to something, or the, usually you say the standards,
Sure.
industry standards, something like that. So we can come up with something else on that. That's a good thing, looking out so that we don't have to have any disagreement on interpretation.
That's all I got him for.
Okay,
Yeah,
any
if
other?
you go to our floodplain ordinance stuff that we have in chapter 9, this is all spec'd out in that ordinance with the city engineer. So the city engineer is the designated person that has final say on the calculations.
Anything else on page 4? Page 5. Page 6. Page 7.
I got one on page 7. Maybe 2 things on page 7. Under lot, we define a lot as a contiguous and separately delineated piece of real property. Then we have lot corner, and there's nothing there. We have lot double frontage, and we do have something there. We have lot flag, but separately we have flag lot defined, so we could see flag lot. And then lot interior, and there's nothing there. So,
Oh, those needed to be added, so, is that, let me just double check. I believe you. No, this one. Okay, Yeah, I think we were thinking we needed to add those. Let me see, I think those might be defined in our zoning, and so we could just pull those definitions over, but, and maybe they were just slotted to see if we use them in here, but that's good. So we need to add interior. Even though we don't have flag lots, we still, in my opinion, need a definition of them so that we know what they are and that we don't allow them. And then corner lot, yep.
and we do define flag lot on page 4 as a flag lot. And so, I don't know, maybe to be consistent with what we did with streets, maybe on flag lot on page 4, you say C lot, whatever, C flag lot,
That's a good catch. On page
See lot flag,
C lot flag.
comma flag.
Yep.
Yeah, under definition for lot. And then,
Well, all of them, right?
Yeah,
When you
for
want it
maybe
for corner lot, flag lot, interior lot, C.
double
lot.
frontage
Okay.
lot too,
Sure.
yeah. Yeah, to be consistent. And then, and this is a question that I had just maybe for my own education here. The difference between a lot and a parcel, so a lot is always within a subdivision and a parcel not necessarily?
That's correct. A lot is within a subdivision and a parcel is typically described by meets and bounds and not within a subdivision.
And then you have remnant and track that's also used out there.
Right, but that's true. So maybe in a subdivision, you might have a small detention basin that would be designated as parcel A. So yeah, you're right, a parcel could be, but the way I look at it is generally lots are in subdivisions, parcels are not. And they are treated separately on how they're eligible for lot line adjustments, or a parcel boundary line adjustments. There's two different statutory procedures for a lot line adjustment versus a parcel boundary line adjustment. And we're working on amending those this year, by the way.
Are all lots also parcels or not?
No,
Okay. That's fine.
they're mutually exclusive.
Got it. Even though a lot of people in their just vernacular might use them interchangeably?
Yes. And that's why I always say, is it a lot? And then meaning, is it a lot in a platted subdivision?
Okay. Well, that was,
Or what's your parcel number at the county, or what's
Well,
your
that's true, a lot does
land
have a
serial
parcel number.
So it's interesting, there's a ton of names for lot, parcel number,
Yeah.
land
But from
serial
a
number.
technical, legal standpoint, I don't consider a lot a parcel, but
Right.
that is, it's true. We call it, they have parcel numbers. So someone considers it a parcel.
there you go. You learn something new every day.
Not Centerville.
Lisa, it looks like there's just an extra line. I don't know if you care about spacing issues, but there's an extra hard return between subparagraph B at the top of that page and land use permit.
Oh, yes, because that was supposed to start on the next page, but.
Okay, anything else on page 7? Page 8. On page 9, I just have a very minor thing. On public meeting, that Utah code section, the section symbols are squished right up next to
Yes,
code.
I've got that. I don't know why I didn't correct it. Okay.
I have a question on page 9. And this is, again, just kind of a general question, maybe to make us all better commissioners. Under public improvements, we list streets, curb gutter, storm sewers, other similar facilities. And I guess this is kind of related as well to utilities later on, maybe more utilities than this. But has there ever been any discussion within the city about including like Utopia as a utility or something like that, the infrastructure related to that?
Under our application process, they are utility providers, so they have to contact, under state law, they have to contact will serve letters to all utilities, and Utopia is on that list.
So we kind of make a distinction between utilities and in public improvements. And I can see what you're saying here, though, because, well, sometimes sewer or stormwater might be in a utility or enterprise fund. But I think for purposes of the subdivision ordinance, the definition of public improvement is used as part of impact fees. So it might be an impact fee question of public improvements, or mainly on the bonding. So what do you have to bond for? And right now you have to bond for public improvements. And we're debating at the land use task force with private developers, because we also, and I thought about just adding this to our own code, is we interpret public improvements at the city level to also include anything of a private nature that mirrors public improvements. So think about Porter Walton. We actually require them, or we may require them, to bond for a street if it's providing access, even if it's going to be a private street. Or we may require, we don't always, but we may require them to, bond for certain private things. So, but that's being debated at the state level now, because a lot of cities do require them if it's like a public improvement, like a street or
Storm drain.
a storm drain system. Storm drain systems might be private, but we want them to bond for it, because as soon as you subdivide, you could technically sell a lot. And then that lot, if they never put it in, would never have storm drainage. So the city's position, municipalities in general and city attorneys, we believe that anything like a public improvement should be bonded for, to make sure it goes in so that the lot is made whole. But we're kind of going back and forth right now. So that's an interesting question, but.
But I mean, so kind of along those lines, and again, maybe this is, like I said, more of a utility question than a public improvement question, but when you're putting in a subdivision, for example, I'm jumping ahead, sorry, but under utilities, we talk about culinary water lines, irrigation lines, storm drains, electric power, natural gas. So cable television and telephone transmission lines, those are very similar. We don't require developers to do any of that stuff, or do we?
No, just the public improvements, because the power is run by another entity and the natural gas is run by another entity, they're just required under the state law to contact them and negotiate the service things, but they don't have to bond for the power or the gas or the cable.
Okay.
And we also used utilities in the subdivision ordinance to determine when they can get a building permit. So all wet utilities have to be in and an all-weather surface on the road before they get a building permit. So
Now,
again, once we finish with the code, we can search utility and see how we use it in this section, but that's one section I can recall.
Utopia has been somewhat a little bit different, is now that they're more in a functioning situation and contact, and they can put in their conduits and things that they want to put in place. But the city has in the past placed forward in behalf during a subdivision the conduits for Utopia as part of our agreements or whatever we've done to help Utopia be successful. But
Especially when they're redoing roads and
yeah,
stuff.
but it is less and less now because Utopia is functioning better on a crew system and responding to getting services as new development comes on board.
Well, I remember Randy saying that he would talk to them and let them know when they're completely redoing a road so they can get in there before, instead of ripping up the road after the fact. So they're doing better at coordinating as well.
You know, and just looking at this definition, though, we could say cable, television, and telecommunications transmission lines, because we're not just talking telephone.
Yeah.
And then that would include,
Yeah.
unless, but again, we may want to see how we use it, because then it means, I don't know who we do the will serve letters from, but you could have a house without having cable TV. So we usually just require the will serve from the power, gas, sewer.
Okay.
So related to utility, should we specified public utility? Should that go by utility, or should just?
So when it comes to utilities, this is also governed by state statute. So there's just a general term of art, utilities, and so we're defining utilities in general here. But if you go before, there's also a term in state statute that says specified public utility. Mm-hmm. So these are the big ones: the electric corporation, the gas corporation, telephone. And then those are governed by Title 54.
Okay.
The cable company is going to be governed by Federal Cable Act and other things, so.
Okay.
Lisa, here's just a minor ticky-tack thing. When I was taught how to type, it was always 2 spaces after a period and 2 spaces after a semicolon. I understand that I'm a real fuddy-duddy because the times are changing and now they're only doing 1 space between, which for somebody trained to do 2 is really tough. So for example, I'm looking on page 9 at specified public agency. It has 2 spaces afterwards, but the immediately next definition, specified public utility, only has 1. So to catch myself when I'm trying to make sure things are consistent, I'll just run a search for a double space and replace them all with a single space, and just to keep the entire thing consistent. And because I have OCD when it comes to stuff like that, I would just want all the spacing to be the same.
Yeah, I agree. And some of this, again, the consultant drafted it, so I was working with different justifications and different font, and then I converted the font to Arial, so there might just be some formatting. But the nice thing about MCO, they're exactly like you, and they want everything the same. So actually, they will convert. I think they convert 2 spaces after the period to 1, and they convert 2 spaces into 1 between paragraphs. So they just automatically do a lot of that, and they don't even give us a choice. So hopefully, on the, I'm not sure if they have an automatic after a colon, but.
Well, and if we're getting to this if we're getting to this detail, I do have a
Yeah,
couple
I saw
other
them, like, it's-
things.
There's one there too
On
there.
page 9, Ally, the colon afterward is not bolded. On page 10, on freeway, there's 2 periods at the end of the sentence.
Yeah.
I mean, if you want those types of things.
Before we go to page 10, is there anything else on page 9? Okay, page 10, we picked up the double period in subsection G. Any
So
other
wait, where was that? Page 10?
Freeway.
freeway?
Got two
the end of
periods
the
at the end of
sentence.
freeway. It's G freeway.
Oh. Mm-hmm.
And Lisa, if we're gonna be consistent on the definition of subdivider here, which is not a state definition, we've got the or at the end of each.
Right, I circled
So-
that, because I would rather not put
Yeah.
or.
I would take those out too.
Mm-hmm.
Okay, any other comments on page 10?
And then the other comment was, make sure that the colon is either,
Bolded or not
Bolded
bolded?
or not
Consistently bold or not
It
bold?
should be,
It
it should
should
be
be
bolded.
It would look weird without.
Yeah, if it's next to a
If you're
colon.
following Chicago
yeah.
manuals, so.
Okay, any other comments, or any comments on page 11? Picking up that or at the top of that page in subsection C. Page 12?
Yeah, I've got one thing on page 12, under unincorporated. I know this is highlighted as a state definition, but it says the area outside the incorporated area of the city, but do we need to be a little more specific? Because Bountiful and Farmington, West Bountiful, they're outside of the city, but they're not unincorporated. Do we-
right, but it's of the city, so anything outside of Centerville, well, let's see, the area outside of incorporated Centerville, I guess is what.
But,
The area outside of the incorporated boundaries of Centerville? Oh, but I see what you're saying.
but
Oh,
not
okay.
also included
But-
in another incorporated
Oh.
city.
It would technically include St. George.
Well, so maybe we should say the area outside an incorporated area of a city. But this is one where we need to see how we use it, because if we're saying unincorporated, meaning, well, I guess that would be outside.
You could say within the boundaries of the city.
What?
The area outside of the incorporated area within the boundaries of the city.
But
But
make
it's
sure
any city.
but make sure we don't inadvertently lump in other cities.
Yeah, I would want to look, before we start
Yeah, we
messing
need to
with this
see.
definition, particularly since it's a state definition, I would want to look and see how it's used in other portions of the code before we make a change to the definition.
I agree.
But I think you're technically right.
Yeah, that's a good catch.
A minor issue, Lisa, under the definition of water interest, sub-paragraph A, just that section
Same
symbol.
thing. Okay, I've got, I
Okay,
don't know why these didn't.
anything else on page 12 or 13? All right, do you need, I can't remember, do you need a motion or something from us, or are you just good with the
No,
comments?
because again, this
Okay.
is just a draft, and so when you see it at the end and we have the public hearings, it will be more familiar.
Okay,
And on some of these, if we're making policy changes and things like that, I might bring back red lines to see if you like the changes, but on this chapter 1 and 2, I don't think we need any red lines at this point. I'll just make the clean changes and make those consistent.
great. Thank you to everyone for your
All right,
close
yeah,
read
thanks.
of those. All right, moving on to agenda item number 3. Yes. Well,
Yeah.
Corey, okay, so let me pause for a second. So we have an agenda item, number 5, which is to discuss Main Street Table of Uses, next steps. I understand that maybe some people in the community misunderstood that was scheduled for a public hearing.
We didn't notice it for that way.
I understand that, so I'm just wondering if, and this gentleman that is sitting in the audience, I'm wondering, is that the piece that you're here for? Yes, he's nodding yes to me. Is there anybody that's on, can you see how many people are online? Because that's something that I'm happy to move up in the agenda, just so people aren't having to wait until the very, very end.
You're online?
Just one.
Okay, just one.
It's just,
You know, I think I'm still going to go ahead and proceed as ordered, because I think that there may be some people that are waiting to appear until later, and I would hate to bump it up out of order and then
I
have
agree.
people show up and say, why did you take it out of order? So I think I'm going to go ahead and leave it.
I agree with that. Can I just ask, is anyone else freezing in this room? Okay, just wanted to make sure
Actually, okay.
that I was the only one literally freezing to death.
I'm usually
Right up
freezing,
here.
so
Okay,
I think it's just
cool.
you.
Okay.
Okay, well, so I'm going to go ahead and leave it the way that it's noticed, just so that if anybody is tuning in or intending to show up in person, that they don't feel like we've taken something out of order. The good news is that we have some really good training, and sometimes I'm a little, I joke a little bit from my position here, but I really do mean that. I think that this training that Lisa provides it's really interesting and is good. So if you don't mind sitting and listening through it, it's helpful for us as well. So, so next up then on our agenda item is number 3. I've asked the City Attorney Lisa Romney to provide us with some training with regard to the distinction between legislative and administrative decisions and the applicable standard of review for those decisions. This was a training that she had provided early on when I was first appointed to the Planning Commission about 3 years ago, and I thought that it was a really helpful discussion to help understand what the difference is between what the city council does and the power and authority and the standard of review that they have versus the planning commission, and what authority and what standard of review they are applying in their decisions. So since we have some new members on our planning commission, I thought that it would be a good thing to dust off and have her do, and she has graciously agreed to provide us with that training. So with those prefatory comments, I will turn the time over to Lisa.
Great, well, thank you. Yeah, this training will be a refresher for some of you, and it will be new for the new commissioners, but I do think it's always good to review some of these distinctions. Sometimes they seem really technical and just fun things that lawyers like, but actually the decisions that you make turn into case law. Some of these actually get appealed, and we do have a lot of good direction from the Utah courts on what kind of information we need to make your findings and your decisions legitimate and upheld by the court. So with that, I didn't bring my little clicker, Corey, so maybe if you could just go to the first slide for me. So I always start with this one just because I think it's good for the Planning Commission to understand all of the different kinds of applications that you get. So sometimes we give new commissioners little one-on-one training, and this is one of my slides for the one-on-one training, but because you really have to see the big picture before you can get down into the detail. But there's a lot of decisions and applications that you see. So just in the last year, you know, we've looked at some general plan amendments. Most of them are not enactments, they're just, we're amending what we have. And then you amend your zoning code. You amend your zoning map, which is the rezones. Then we have our subdivision ordinance, which is kind of on the same level as the zoning code, just for subdividing. And then you have conditional use permits, site plans, subdivisions, special exceptions. And then there's a lot of other little things that used to be on this slide, like non-conforming uses and waivers and things like that, but I just narrowed it down to these because these are really the ones that you see. And I think the last time we did it, when I did that chart of what you spend a lot of time on, was kind of interesting. I think you spent a lot of time on zoning code amendments and site plans, was what the data said. So for the Planning Commission, certain decisions you make the final decision, or certain applications you're making the final decision, and for others you're just making a recommendation for the City Council. So when you're reading your packet, always look, and you know, you can kind of quiz yourself, okay, this is a text amendment, oh, that's going to be a recommendation to the City Council. And that always helps too when you're making a motion, or if you're going to make a motion that's not already in the staff report. You have to think about, am I making a motion to approve this because the Planning Commission has the authority, or I'm making the motion just to recommend to the City Council, and they have the ultimate authority. But in either case, excuse me, whether you're making a final decision or even a recommendation, you need to have appropriate findings. And I think this Planning Commission is really good about the findings. So again, this is mainly a refresher. This is an excellent, knowledgeable Planning Commission. But if you have some questions, hopefully we'll get into the details of those findings. So, and these are just a few things on the standard of review. So we do still have some deference at the in the statutes that our land use decisions are going to be presumed valid unless they're arbitrary, capricious, or illegal. So really, if you're doing your job and you're looking at the right reasons and the right issues, basically your decision will be upheld. But if you're not looking at the right factors, or you're basing it on discriminatory factors, then it might not be upheld. But that whole, whether it's arbitrary, capricious, or illegal, there is a different standard of review, whether it's a legislative decision or an administrative decision. So that's the main point. We always talk about the standard of review, but that standard of review is kind of under the umbrella of arbitrary, capricious, and illegal. And you'll get more deference depending on what kind of decision it is. So on this one, this is just the chart of, we have our legislative decisions and our administrative decisions. So legislative decisions, and you know, I could just tell you, oh, the zoning code is legislative, the general plan is legislative, but I'd rather have you understand why they're legislative. So that's what this chart is that, you know, the legislative decisions are really decisions to establish the law. So this is the law and the statutes and the ordinances, mainly at the city level, the ordinances that we adopt, that is a legislative act. And only the city council has the legal authority to legislate for the city. So all legislative decisions are made by the city council. The Planning Commission doesn't have that authority. So then we have administrative decisions, and administrative decisions are those that implement the law. So first we set the policy in the law, and then we implement it, meaning, oh, we're just looking at this application for conditional use permits. And we are applying, you know, factually distinct applications to those, the factors in the ordinance. And most of our administrative decisions are made in the land use arena by the Planning Commission. Staff is recommending, has recommended for a few years, that all administrative decisions in the land use arena should be made by the Planning Commission. And so you'll see, as we're redoing our subdivision ordinance, we're trying to bring some more of those decisions back down to the Planning Commission, because there's very little discretion in administrative decisions. And it's difficult for city council members who are elected officials to, there's a lot of pressure for those decisions, and it's hard just to apply the law. And so I also think that I kind of like the separation of powers. You have the city council that sets the policy and the Planning Commission that implements it.
Lisa, do you think that this is an area where the public often has a misperception? Because I have been here on this Planning Commission when people have come up and said, but we really shouldn't be doing this. And they feel very heartfelt about it. And sometimes I completely empathize with them. But we as a Planning Commission, we have to follow what the law is. We don't get to make the law. We just have to apply whatever the law is. Do you think that, do you think that I'm right in thinking that that's a misconception often among the public? And B, is there anything you think that we can do better to help the public understand this part of the process?
Yeah, I do think I don't think that the public fully understands, but I do think, you know, the more we give the training and the more we mention it in our meetings, that's helpful to educate the public. And, you know, in the Walmart matter, I think we did a really good job kind of explaining up front in some of those hearings, this is the law. This is the standard that we have. We are here to review the ordinance and see if this application meets the ordinance. If you have any public comment regarding how this application does not meet the ordinance, that's relevant public comment. Public clamor, you know, I'm just worried about this, I don't think it's a good idea, I don't like those kind of people, that is not something that the Planning Commission or we can take into consideration. So it's more of a educating the public, but helping them understand that that's your role. Sometimes I think it's apologetic, which I don't really like that approach. I think it's more helping them understand that these are the rules and the parameters within which we make decisions. It's a good framework, because what happens, I mean, decisions can be so arbitrary and so unfair and so inequitable if you just made a case-by-case decision. And I think this is what's happened with CUPs is, you know, CUPs used to just be, well, if we like it, we'll do it. Well, you can see that the statute just got more and more specific and said, no, you can't just do this. This is an administrative decision. If we meet the ordinance, we should be approved. And I think that that's fair, because we have a lot of authority in setting the rules. We need to have that leadership and that vision in setting the rules. Now, we can't see everything, or foresee everything, and you may say, okay, on Main Street we want some other uses, let's look at that. But just because somebody comes through the door and does something that's permitted by code that you don't like, that's not the time to change the rules. That's not fair. The rules are there. I bought the property in reliance upon the rules. I should get to do what I want to do. And to me, that's fair. If we now have learned some things that are not, you know, compatible, then we go ahead and change the rules. But like I always say, the test case that pushed, you know, it made us realize that our ordinances had a gap, they get in. That's just the way it goes, but you can immediately shut the door.
But I think you're also right to point out too, is there anything we can do? This is a struggle that the planning community has wrestled with for quite a number of years, even before I became a planner. You know, public participation in the general public's mind is that what they come here to voice is a vote. And the assumption is that every time they speak at the mic, it registers a vote. And if the people come out with 10 against it and 3 for it, and you vote for it, it befuddles them. They don't understand that process. And as part of the planning's division is trying to do outreach into the schools and everything else to try to get down to where, you know, the education of how your government works is down at that school level, so that they can grow up into understanding what it means when they come to a public meeting. But, you know, as you mentioned that, just while Lisa was talking, I was like, well, you know, what can we do? You know, I don't think we can fully fix that, because people are people, and how they perceive the world is what's real to them. But I think, you know, we've made an improvement. I don't know who it was on the commission that said, you know, I want to see administrative
That was
versus.
Becky, and she should get full credit for that, because
Yeah.
I thought it was an excellent
I
suggestion.
I think that's a great, you know, step in that direction. It's obviously not a cure. Just thinking, you know, I'm wondering is we have public, that we could have a brochure about the administrative decision. I don't know how many people engage quickly, but something that's a real quick information. You know, I don't know if it's a note that we include as part of our agenda when we post it. We just have to put it in multiple places, because you don't know when it's going to grasp a reader.
When we have a meeting like that where we could anticipate that type of discussion, certainly if it's an administrative decision, maybe that's a little flyer you put at the table over there, so people sign in, they pick it up, and then they're sitting there reading it while they're going, oh.
Yeah. My other brainstorm that I didn't want to say to you is that we have a little light board back up here, and it just lights up when it's administrative, and it changes when it's.
I think that's part of the reason why there is confusion, especially with the planning commission, is that we deal with both of those on a regular basis, and sometimes within the same meeting, we're hitting both of them back and forth.
And it's really confusing what you're doing.
Yeah.
Well, and we talked about, you know, removing the public hearing process from some of our administrative decisions. We had that discussion because what happens is people come to the public hearing and expect that it is the vote they're getting when it's an administrative decision and they followed the ordinance. But we decided as a body that it was important to still have those hearings, public hearings, because there's relevant information that is sometimes provided. Not always. Sometimes it's just the clamor, and it's unfortunate that we have to make people upset when someone is following the ordinance. But occasionally there are times where we receive public comment that allows us to understand if we're applying the law correctly to the specific situation. So that's a choice we made to have that hard part of our job, I guess.
Yeah, and I don't disagree with that decision. I just, knowing how I viewed this process before I was sitting in this chair, I had a very different understanding of what the Planning Commission did. The first time that I ever stood up as a member of the public and made a comment, I had a very different understanding of what this Planning Commission did. And I think that that was just because I didn't have knowledge about the process and about this distinction between legislative decisions and administrative decisions. And I really like the idea of having some one-page flyer, maybe even along the lines of what Lisa has included in her PowerPoint presentation, that we can reference, particularly when there's, really contentious decisions, like, the HFOCA decision comes to mind. I think that that's a great idea.
Mm-hmm. And well, historically, we have tried to get this information out, and I think that one councilwoman actually put something in our newsletter once. We were doing a little education in our newsletter, and we had a legislative administrative thing in the newspaper or in the newsletter. I have prepared, although they don't get widely circulated, but much like my open meetings handout, I do have a handout. I try to keep them on one page, but I use the front and the back.
Little white paper.
My blue sheet on legislative land use decisions and a blue sheet on administrative decisions. That's probably a little much for the door. People are not going to read these, but it is something that perhaps I could double check and make sure it's still updated and get on the website or something. So there's the detailed handout. I do think we could come up with a flyer at the door. But then the fourth thing might be that you just want to try for 6 months or so is before each public hearing, you just take 2 minutes to say this is an administrative decision. As an administrative decision, the Planning Commission is looking at the ordinances and whether or not the application meets the ordinances. Things that we won't be looking at, or just certain things, but again, that's what we did in the Walmart hearings and said, look, if you give us, this is what we're looking for because this is what's relevant for our decision. This kind of information at the public hearing is not helpful, and sometimes it's detrimental because it can impact, it could give someone some argument of why you made your decision. It wasn't based upon the evidence, it was based on the public clamor. So again, I think those are the 4 things I have: the newsletter, my blue sheet, very detailed, and maybe a quick, nice, user-friendly flyer at the front, and then a public hearing, maybe a paragraph for public hearings. And even if people aren't here, we're just saying, this is what an administrative decision is. This is legislative. Because I do think they see the agenda, and I think that's been a great thing. I've even heard from other cities that they really like that, and I like it. So I think we could just maybe consider coming up with a short paragraph on legislative and administrative decisions.
Lisa, what I would like to see you do is add that to your to-do list, and it's not anything that's urgent, but I think that it would be helpful, and I am going to advocate that when you do it, that you think about putting together something like the flow chart or the diagram. And I say that because people learn differently. Some things impact people more. If you tell me something, I'm not going to retain it nearly as much as if I see it on paper, right? And sometimes illustrations, I think, help even emphasize it more than just reading it in paragraph form. So what I would like to see is you put together something that is similar along the lines of
Okay,
this.
so you're talking about the flyer.
The
outside.
flyer, just the one
okay.
page, right? And you can refer them to more detail if they want. But
Yeah,
I just think it would be
we
helpful.
can post that on the community development page for the planning and zoning. We can, link things as we write reports so that they can have that link to it in the reports. So I think there's some greater education,
Yeah.
that's what I'm saying.
Well, and you could even, I mean, if we wanted to, the first box on both of these is just very helpful, just a very, very broad, basic understanding of this is a decision which will apply the current laws and policies we have in place. This is a decision which will establish law and policy for our city. We could say that in our, I mean, that takes, what, that took me 5 seconds.
Exactly, yeah, you just
I
have
mean, you
a
can say
paragraph.
that, which is not even a
Sure.
paragraph, it's like not even a full, complete sentence. You just say that with every single thing, or have that in a very
Yeah,
easily
sets policy.
accessible.
Administrative is implementing policy.
Applying
This
the
is
policy.
general, yeah.
So I don't know, just continuing to have that in our vernacular might be important, especially for you when you do.
Yeah, I'm open
Shaylin.
to that. I do think that I've become convinced that the more that we educate the public about what it is that we do, the better that they're going to understand the process and be able to provide better comments and better feedback and more helpful comments, and they'll be less frustrated, we'll be less frustrated.
Yes, and that
and
would-
the process will work better that way.
Yeah, and remember that a lot of times this is someone's first interaction. I mean, we hear it all the time, sorry, I don't know what I should do.
Yeah.
You know, so again, when you open the public hearing, it doesn't really take that long, maybe
Yeah.
60 seconds to say, when you come to the podium, please just give us your name. We don't need your address, but maybe your city of residence. And if you can keep your comments to 2 minutes, and, you know, what we're looking for here is comments on this administrative decision, something like that, so.
I like it. I'm gonna work out some language. I'll run it by you, Lisa. But I think that that's a really great
Yeah.
idea.
And it's really nice also, I always try to tell people that are running the meeting to remember that, you know, the public, once you say, I'm gonna open up the public hearing, we're just like, I mean, they're all of a sudden, oh my gosh, I don't wanna get up first, or they're worried about it, or, you know, they're thinking, I have to get up and do some public speaking, and so when you say, okay, I'm getting ready to open up the public hearing, before I do that, let me tell you this. So they hear public hearing, start getting their, their thoughts, and then it gives them time. And same thing when you repeat the motion at the end. I know we want our meetings to be efficient, but sometimes there's things that actually help to say, okay, we have a motion on the table, the motion is to approve, because the public may be like, where are they? Or even the person taking the minutes, like, what was that? So it's nice just to slow down and say, the motion is to approve with conditions 1 through 5. You know, is there any further discussion? And then when it passes, say, okay, great, that passed and it's been approved. And it also helps staff, because remember, you're just ready to go on to number 2. Well, we're trying to get our presentation ready for item number 2. So even some of the slowing down does help the people in the background and the public to understand.
Excellent
That's a good
suggestions.
point.
I'm sorry, Elisa, I didn't mean to divert you on your
Okay,
presentation.
no. Okay, so we've talked about this. I think this group understands these are the legislative decisions: your general plan, your zoning ordinance, your zoning map or rezones, and your subdivision. Those are your legislative, and those go up to the city council. So the standard of review for legislative decisions is the reasonably debatable standard. And it's as broad as it sounds. Is it reasonably debatable that the act you're taking will promote the general welfare? Or even if it's reasonably debatable that it's in the interest of the general welfare? It's not that high of a standard. So, and I know I've been saying this for years, but I'm not aware yet of any decision, any legislative decision of a city in Utah that's been overturned by the Utah courts. And I'd like to keep it that way. And I will say we're getting close. Some of our reasons to deny rezones that are not based on the general plan, you know, or other reasonably debatable grounds, we're getting close. So if it's a low standard, but you know, I think that even in these kinds of decisions, we can consider public clamor, which sounds like a bad word, but it's not actually. I mean, the Utah cases use the term public clamor. They actually talk about it and say, this is just neighborhoods coming up and saying, I'm very concerned about this. It's going to change the nature of the community. You know, it doesn't have to necessarily be a negative word. It just means they're coming out and they're saying, I'm really concerned about it, but it's not evidence. It's not any supportable expert opinion or evidence. It's just, I have a real concern about this. But if you can take those concerns from the community in the public hearing and repeat them in a way that puts it into the reasonably debatable framework, that's what we need. Like, I've heard a lot of concerns here about how this is going to change, you know, the traffic around here, the nature of the community. There's some concerns about whether it meets the general plan and then, you know, going to the general plan. So, because a lot of times we will have public hearing where there are grounds that they're bringing up that may be discriminatory. And I think it's our role to show the court or to show the applicant that we understand why we're making our decision. And our decision is based on the general plan, the traffic, and the nature of the community. And if you repeat those things, then it's showing, without saying, that we're discounting those other reasons. So we are given broad discretion in these
Renters don't
legislative.
wash cars. That's my favorite comment. Renters don't wash their cars. That's my favorite quote
That
in
was
the public
before
hearing.
Quick Crack Car Wash.
Which is absolutely lovely, by the way.
Nice color.
This color's
Very
great.
nice color scheme.
Yeah, it's like psychedelic.
And I can see it right from Parish Lane.
I know.
Yes,
I
I'm
can't believe we even
Does have a
debated whether that was even visible. Sorry. That was
Okay.
definitely visible.
Sorry, going back to
Okay.
training.
So the next one, the next slide is just saying these are the kinds of legitimate findings that you can use for legislative decisions. That, again, reading right out of the general plan and that language in the staff report, that's always a good thing to do. To say, well, the general plan says we're looking for, you know, medium density residential. This is consistent with the general plan. You can look to existing uses, what's around it in a, you know, like a rezone. Any adverse impact on adjacent property. I don't love this one because any change could be argued it's adverse impact, I mean, to someone, so I don't love that one. But, you know, looking at transportation, population, housing projections, orderly development of the city, whether we have utilities. So this was one that we've used this clause to deny rezones that we did not have adequate facilities. And this one I don't mind because it's right in our code of consideration for rezones. So we have used that. And you can consider public comment. What I always tell the city council and the planning commission as well is, let's not base it solely on the public comment. There's all these other things that we can list it on, so at least have one other rather than the people don't like it, so we're going to reject it. That, in my mind, is getting, that you're now the test case that's getting closer and closer. Is that, you know, reasonably debatable? I think you're still probably going to win it, but I really don't want to go to court on that. So public comment plus one or two other legitimate reasons, reasonably debatable. So administrative decisions, these are our everything else, the conditional use permits, the subdivision, site plan, and the standard of review on administrative decisions is much higher than the legislative decision, because the courts are saying cities should have a say in how their city builds out. We are going to, it's not for the courts to decide how Centerville should look, where you want your setbacks. That's for you to decide. But once you've decided that, and it's merely implementing that rule, now you need to follow the rules that you adopted. And we're not going to give you as much discretion. So the standard of review for administrative decisions is the substantial evidence standard. And so your decision has to be supported by substantial evidence in the record. 2 points, substantial evidence, and that evidence has to be in the record.
Yeah, my favorite experience when there was a Walmart, I received a Christmas card from the public after Walmart. They did one of those, it was a nice Christmas card. But you open it up and they'd cut out the letters from magazines
Ooh.
and pasted them and
Walmart
said,
sent that to you?
no, this was during Walmart. He received it from a citizen. And the Christmas card and letters said, and again, this is implementing, and said, what do you not understand about the word no?
You still have it?
I think so.
Yeah.
I have
So-
a collection of newspaper articles too. So,
Yeah.
so it's funny that their view of it is that we don't want Walmart, and they saw me in my recommendation is, the feedback is that that I was controlling the outcome. It got so bad that one time I wore a blue shirt to the meeting, and the newspaper commented on the blue shirt, and did it mean Walmart or no? That's how. So people really feel like these meetings and that substantial evidence was really critical, because Planning Commission ended up in a tie vote, which is a denial, and ended up going to the Board of Adjustment for decision and whether that denial was appropriate or not. And it was remanded back to the commission, and you will approve it, but we pleaded with the Board of Adjustment but don't set the standards of the approval, remand it back down to the Planning Commission to set those standards of approval. So it was a tough case, and evidence had some negative to it in the evidence. It just overwhelmingly needed to be approved.
Yeah, we like to use the Walmart test case because it really did hit all the boxes on a lot of these, the standard of review, and lots of things were brought up and challenged, and even if whether planning commissioners had conflicts of interest, et cetera. But excuse me, on the administrative decision, the substantial evidence standard, this sounds like we're getting too detailed, but I think you really need to understand that it's the quality of evidence that's adequate to convince a reasonable mind to support the decision. Okay, so would a reasonable mind agree with the decision that you took based upon the evidence that you had? Now, it's not just a little tiny bit of evidence, but you would think substantial evidence means like a lot of evidence, but the Utah courts have said it's actually, it's something less than the weight of evidence. So it doesn't have to be, by a preponderance of evidence, or like in the criminal arena, beyond a reasonable doubt. That's a lot of evidence. And then there's the preponderance of evidence, which is pretty much, that's substantially evidence, and then there's just evidence. So this is where we say in Walmart, I think I spent my Christmas vacation with all the evidence, and I did, I don't know, what was it, 30 findings for and 23 findings against. So you're going through all of the evidence and saying there's actually this much evidence, or maybe it was even. Let's just say it was even. 24 findings against, 24 findings for. Yeah, it's going to impact traffic, but it's not going to impact traffic that much. Or it's going to, change. We don't like the buffers and all of that. But so in the Walmart decision, it really could have gone either way. So the Planning Commission had enough findings either way. They just had to decide which was the way that they felt that the evidence was going and how it met the ordinances. So I think that's important, that if you take one thing away, substantial evidence doesn't mean the weight of evidence. It's just, you have to have enough. And that's pretty technical. So if you can take that away, that's great. And the findings on the administrative decision is, again, as we've kind of talked about, you have to look, what does the ordinance require? And I love that this Planning Commission pulls up on municipal code and says, well, it says this, or it requires this. That's what you're asked to do is, and our staff reports are very detailed. It goes through every item of the ordinance for you and says, here's this requirement. Here's how it meets it, or it doesn't meet it. And what evidence do we have in the record? So under administrative, you have to have evidence. If somebody stands up and says, Walmart's going to reduce my property values, is that enough? That's enough in the legislative. It's not enough in administrative. And so you have to have a real estate agent or someone that's an expert in the area to stand up and say, I've done an analysis here and it's going to reduce property values. So this is what we did in Walmart. They had their real estate agents and Walmart had their agents, and we talked about property values one night. And then somebody got up and said, this is going to increase crime. Okay, not in an administrative decision, that's not enough. And we helped the public understand that's not enough. So they went out and got crime statistics of every Walmart in the country and what happened when a Walmart came in. And then Walmart presented their crime statistics. And we even had a letter from the police chief saying, I think this is what's going to happen. So I do think in that, the public actually, they presented a lot of information. They presented a traffic study. They presented the crime statistics. They presented the property value. Oh, and the sound. They had somebody that was a specialist on sound. That's the kind of evidence that you need in an administrative decision. I don't think we're seeing that sophistication lately on administrative decisions. We're just hearing we don't like it. So I think what Chair Heyman is bringing up is, yeah, maybe we do need to do a little bit more educating in the public to help them understand what's relevant in their public testimony and hearing on these types of applications. Because it's clear in the case law that we can't consider public clamor. Now, and that doesn't even, can you consider it or can you just not base your decision on it? But really what they're saying is it's not relevant if people don't like it. The question is whether it meets the ordinances. When you set the rules, you had all the power and authority to set the rules, and they're just coming in to do what you said they could do, and that they've expended all of this money in purchasing the property and applying for it. So, oh good, that's it. So any questions? Was there anything that was a surprise or something new or just good reminders?
I thought it was great. I mean, thank you.
Yeah.
Okay, great. Yeah, so for some.
I liked also how you talked about slowing down. I mean, I don't love slowing down. Obviously, I like to get things moving, but I do like that you talked about slowing down for the public's benefit, and I think that's something that we can do. And also, we've talked a little bit about explaining why we are coming to a certain conclusion, personally, and even as a commission. I think that would be helpful for those in the audience to understand, I mean, they can always just read, findings A through C in the staff report, but it's nice if we sometimes can slow things down. So
that reminded me of something I wanted to bring up, and I think this came up in the recent Moab issue with the CUP. There's a recent court case with some of this VRBO housing, but just going one by one. So let's say you make a motion and then you say, I'm voting no because 1, 2, 3. I'm voting yes because ABC. There is some concern when you state your own reasons individually that those are not official findings. And I think in the Moab case, they were kind of challenging that and saying, well, they didn't have any findings for their decision. And the city was saying, well, sure they did. They each gave a 10-minute speech on why they were voting the way they did. But they didn't make it technically part of their motion. Unless you say, I hereby make a motion, because usually you say, I hereby make a motion to approve this CUP based upon the conditions and findings in the staff report. Now, luckily we have the staff report, but let's say you didn't. You just said, based upon these, and then each one of you gave your individual finding. I still think technically you probably need a motion at the end to say, I'd like to amend the motion and add 3 findings and just pick out the best. Because when you're saying no, or even your reasons for might be different than Logan's reasons for, and he may disagree with some of your reasons.
I can
and
guarantee that.
Yeah, so that's why if you're just making your own statement, it's technically not findings of the body unless you specifically list them and then you all vote and agree on which findings you agree on.
And generally, we have as a commission expressed why we're voting nay or in opposition to the majority. I feel like that's what we've generally done, and the majority usually can fall back on a staff report. And there have been some times where we've disagreed with staff, but I think we've come up with findings in those instances. We've been very clear about our specific findings as to why.
Yes, and I think that's good. And I do say, yeah, if you're voting a certain way, help people understand why. Like if you're going to vote no, just say why. But again, in my opinion, that's your personal opinion on how you're voting. It's not a finding, unless the whole body votes on it.
So Lisa, if we disagree, say we supported a motion, but for different reasons, or felt like it merited support for different findings, is the appropriate thing then to, I mean, would I then vote against the motion because like say I amended the motion to try to include my findings, and these guys say, Logan, you're crazy, we're not going to include those. Should I then vote, meaning is it somehow inaccurate or unethical to vote for it, even if my findings didn't make it in the actual motion?
Usually if you're in favor of it, you wouldn't go to that level to vote no just because you don't like the findings. But I think this has come up because sometimes commissioners have requested certain findings and others say, no, I don't agree with that. I don't think that's why we're going there. Or it may be a condition that's going too far. Like for instance, I want a condition that Quick Quack put, paint it a certain color, maybe that people didn't agree. And so I do think as a group, you have to agree on your findings. And usually we do because they're in the staff report. But yeah, if you're making your own motion and you're branching out, I think you do a good job with findings, but help each other. And you can even amend a motion and say, you know what? I actually think I've thought of another relevant finding, which I know Kevin could come up with. I'm going to add this one because I think that's relevant, and that's why I voted. I move to amend the motion to add an additional finding that this, is inconsistent with the general plan. Oh yeah, that's a good idea. We did talk about that. And then you vote on that amendment to the motion, and it's an easy way to just add findings and make sure everybody agrees on those findings.
Well, that came up with the fence height requirement, actually.
Yes, yeah, we were debating the findings.
And that's why I did vote against it, because I did not feel comfortable with the specific findings for the rezone of the agricultural residential type thing.
Okay.
So there are specific times where I feel like we have done that, where we've said there are specific reasons.
Yeah, it could be if
So.
there's something in there. So yeah.
Great. I really appreciate you for taking the time to go through that training. I think that it's a good refresher for those of us who have heard it before, and good for our new commissioners as well. So I do apologize to you, Lisa, because I put a ton on your plate. But since we didn't have anything else on our agenda, I thought let's go ahead and just get our training done so that we can free ourselves up when we have other matters that needs our attention. So let's go ahead and move to item number 4, which is the open and public meetings training.
Okay.
And so I'll turn the time back over to you, Lisa.
Okay, thank you. So this training is actually required by law. The chair has to make sure that you have this every year. I took out, I'm not doing any pictures or any jokes this year, so hopefully we can just go through this quickly.
We don't get to see you scuba diving.
Well,
Come on.
No, not this year. But the interesting thing, I did go through for this to see what legislative updates we had. There were 7 bills last year, 2018, in the legislative session that amended just this section of the code, which is not that big. But most of those were really minor and just changing things for charter schools and transit districts and other things. So the only one that I thought was of any substance that you need to know about is on the annual training required. They actually added something this year that said, hey, if you're required to give annual training to the public body, like the Planning Commission and the City Council, you now need to provide an online web-based option so that you guys don't have to drive anywhere or do anything to get your training. And then there's some exceptions of if we need some one-on-one or something like that. So I need to talk with the league and see who's going to do this online training, but maybe next year you can just sit at home and click through some slides, but I still like the one-on-one because then I get to answer any questions and things like that. But they're kind of going to try and make it easier for all these public bodies to get their training. So
You should offer to do it and put in funny jokes so everyone will enjoy it.
Okay. On the Declaration of Public Policy, I always start with this one because I think this is just the crux of the whole open meetings policy, which is that just remember that the state and city and all of these public entities exist to aid in the conduct of the public's business. So it's the public's business that you're doing here. You know, to keep the big picture that we're actually doing the public's business, and so that's why everybody needs to know what we're talking about on the agenda, and everybody needs to know why we're making our decisions on the record. So, and also I was going to let you know, the state auditor is now tasked with making sure that cities follow the Open Meetings Act. So whenever the auditors come in, they call me. First I have to give them an opinion letter on something, and then they also say, okay, well, when did you give the training for the Planning Commission and the City Council? And then they take some of our agendas, and they have to review the agenda and make sure that we specified things, and then also check our minutes and make sure that we took the minutes. So they do a sampling, and then also if we do closed meetings, they check a sampling of closed meetings. So we are double checked on these. So open meetings, everything has to be open to the public unless it's closed. We don't go into a closed session, but a meeting, remember, doesn't include social events, so we can go to the Christmas party, but just don't talk about the city's business necessarily at the Christmas party if you're all sitting at a table, because now you're doing the city's business and it is a meeting. But if you're just talking about the food or what movie you're going to see, then that's fine. I always put in the notice requirements here because I don't think people, you know, definitely the public doesn't realize how much notice we have to give. We have to give notice under the land use statute, and we have to give notice under the open meeting statute, and you know, a lot of statutory notice. So and we give an annual notice of our meetings and 24-hour notice. So if you want to change something on the agenda, you know, Steve's always trying to add something to the council packet, and I'm like, Steve, 24 hours, you can't change the agenda if we're within 24 hours. So that's statutory. And the agendas, the law is getting pretty specific that, you know, we need to let people know with reasonable specificity what we're going to talk about. And I think we do a great job. We give the type of application, the address, the applicant, and with Novus we have that extra little clause down below that we give a little bit more detail. So hopefully you guys are getting used to the format that we use, but I like to make sure people know where it is and what we're talking about. Sometimes we broaden it a little bit, like we say we're going to talk about the South Main Street 12.48, because we don't know, you might find a different, even though we're only doing one section, you might find a different section, and if we did the notice too restrictively, then we can't take action on that separate item. So sometimes if you see us getting a little broad with the noticing, that's why. I don't think we really need to talk about the minutes, but just know I appreciate the time that the Planning Commission takes with the minutes, and remember that that is the official record. Even though we are also required to take a recording, the minutes are the official record of what happened, and they're kept permanently. So, and we use them all the time to research. We're, you know, every other week we're asking Mackenzie to go research the minutes about something 10 years ago. So we really use them, and we appreciate Avalon and the recording secretaries that do a good job.
Even though we're going to miss her now.
I know.
She's leaving.
But, I mean, Centerville does a great job. I know sometimes people think they're too detailed, but For me, having to go back and read and understand what happened, I love it. So, and again, we do have to have the recording, that's by law, and we have to have that recording ready and available to the public within 3 days after the meeting. So whenever Avalon or I stop the meeting because the recording stopped, that's because technically under the law, we are not supposed to have a meeting unless we're recording it. Now, if there's technical difficulties, we can deal with that. Closed meetings, I'll just give you a separate training if we ever have to go into one. But you do need 2/3 vote to go into a closed meeting. And this is the new, not so new anymore, on the, that you can't send a text message to each other during the meeting, and you can't email each other. So just be mindful, because I know sometimes we're like, oh, send me that PowerPoint, or let me send you this link. Just,
You can't even do that.
you can't do that.
Can we send it to you and then you?
Yes, send it to staff. You know, you just cannot text or email each other during the meeting. And this is what I think
Wow.
you need to be really mindful of, because, you know, as staff, we do hear comments and complaints from the public. Like, I will say, I've even heard, somebody asked me one time, what are they all looking at their iPads for? They thought you weren't paying attention because they hadn't realized we'd gone to Novus and we have this electronic thing. So just remember the appearance of it. It's just, they want to make sure that you're paying attention and that you know what's going on. And I know sometimes it's hard when it's really late, but you know, that's the appearance of things. So hopefully everybody knows now we're looking at these because this is our agenda. But that's the same thing with these sidebars. You might just be making a comment about, you know, the first day of school and how it went for your kid, but for an applicant out there, it looks like you're either saying, hey, I'm going to vote no against this, or if you're laughing, that you're laughing at them, or you're laughing at the, you know, the person that just made some public comment. They have no idea what you're saying. So just try to keep those to a minimum. I mean, I know sometimes I make a comment, but I try not to, because it just, you never know the appearance of it.
Okay, I will stop commenting to Cassie about how cold it is then.
About how what?
How cold it is. I
Oh.
promise.
Just do it on the record.
I'll do it
No,
on the
I know it
I'll do
happens.
it on the record.
Yeah, but
It's cold in
I
here.
mean, there was a commissioner that we had, and he would just talk and talk and talk, and I just feel like, you know, we're right in a thing. Don't ask me these questions. So, but I think this commission's pretty good. I appreciate that. So we are done for the year on our open meetings. I also have the blue sheets on open and closed meetings. I didn't attach those because I thought it was already lengthy enough. But any questions on that, or just a reminder of how to conduct ourselves?
Thank you.
Yeah, thank you.
Yeah, thank you, Lisa. We sure appreciate you. You do a fantastic job. Okay, item number 5 on our agenda is a discussion of the Main Street Table of Uses next step. So in the spirit of clarifying what we've just talked about, this has not been scheduled for a public hearing, so we will not have members of the public coming and talking to us, but members of the public are certainly welcome to listen as we talk through, I assume, I'm going to turn this over to Corey, as we talk through what the next steps in our process will be with regard to that table of uses. So with that background, I will turn the time over to Corey.
Thank you, Chair and Commission members. We held our first kickoff meeting for the Main Street uses. You know, part of the difficulty is when you're looking at text amendments, you're not really putting a sign out on a piece of property and say, come comment on this property and development. And it's difficult to get the word out. Your last meeting, we did send notices, the standard notices. The courtesy notices that went out were we mailed the statement, the prepared statement that it was online, and the agenda notice to all property owners and business owners from parish to Porter, right? Is that correct? We had our GIS and our business license lists and sent them out to everybody. It did turn out to have quite a few people in the participation. I think you heard some general consensus that they have interest. It was awkward because we're not definitive yet. We did show a fairly broad listing of potential ideas for uses. Obviously, from my perspective, the feedback was, yeah, we'd like some flexibility in some uses, and of course there were individuals there about specific interests that they had that they'd like to continue. The Korean barbecue subject still seems to linger in the discussions in the rumor mills and so forth. But it was difficult to say, have we accomplished what we're trying to do? And so in stepping back and thinking about it, we had previously talked about forums or open houses. How do we engage the public? One of the things that Cassie and I discussed, and it was really Cassie's idea, is pointing out to, if we just hold a forum and say, okay, property owners, come again and tell us what you think, it's going to be frustrating for them, as well as, the direction's not going to say, what should we lean towards? So we discussed how to properly maybe engage folks to get some feedback to them, but not something that's trying to address other issues of far and above the use list. But so an example is should we keep the Main Street plan or not? I mean, that's a different type of discussion that we're not really ready to have the discussion whether the South Main Street corridor plan overlay is something we want to keep, modify, or get rid of. That's a subsequent discussion to take place. And so it became this little difficulty of how do we engage it. So some of our ideas, and we're open for your suggestions, is that we still think we should engage property owners specifically. And I think the reason is certainly we heard a little bit from the business owners, and it's not like we're not going to invite the business owners again. I treat this, it will be just like Page's Lane. When we come down to whatever narrowing, what we want to call it, we'll re-advertise that same courtesy notice again. So in my mind, we're still out to engage the general public. We're not finished engaging the broad spectrum or the business owners. But we do need to find some stake in what's happening. And the property owners is a good place. We've got attention of their participation. And it's a good place because they're thinking about the now, probably, but we don't know what their thoughts are 10 years down the road and what they're struggling with. So I tried to come up with just, if I was in my mind, what would it be I want from these information from these folks, without saying, is our zoning ordinance good for you or bad for you? It's how do they see keeping their investments viable? It is a use list, but there is some market issues out there. And maybe from the property owners, as they're trying to secure leases and so forth, they can describe to us and tell us their struggles of what they're, because that will start helping us to grasp a mind about what they're planning about their property. And it's not whether zoning's good or bad, it's what are they dealing with? How do they view that into the future in keeping these investments viable? What concerns? Great comment we heard way back during the O'Brien site that Brighton came up with was, it was his 401k, it was his retirement system. He bought out neighboring properties that were struggling and people needed some bailouts, and he looked at it and said, well, I could use this to expand my business. I could use this to maybe in the future. And it really, his future of why he engaged with his property and the surrounding is that that's how he set up his retirement. And I think that's important to know. We may not be able to fulfill the goal of the retirement. I don't think that's our goal, is to maximize and hit some level of retirement income, but you can get a picture that his investment was for a long haul. That was the reason of engaging, and that's good to know, because from my standpoint, we have 86% or 87% on Lisa's research that are local owners, and that's unique. And I hear, what's unique about Main Street? Oh, there's nothing here, or there's some old buildings but it's not. It's unique. It's not unique. It's unique. It's unique. It's because there's some long-term investment owners, and and they're local, and we need to understand what they're thinking. Constraints and opportunities and they're experiencing in the market. Again, back to the Ryan property, when we passed the zoning ordinance, during their discussion, they told us that they spent 2 years marketing the property. They put a marketing plan together for the property and went for 2 years and found somebody. Unfortunately, that didn't pan out for their investment into the future. Good or bad, it's not the issue. It just didn't pan out. So that's a constraint, opportunity and a constraint. How long did it take them? What are the difficulties with that? And why I think that's important is just it kind of wraps your mind around is the use broad enough right now? Is it not broad enough from their perspective? And what can we think about it? But that's only one stakeholder. The other stakeholders is the residential neighborhoods behind. We know that. We've heard that through the years. And I think the O'Brien proposal really brought a crescendo to what we've heard through the years about what was not working for them as a neighborhood and how close they are. So they're a stakeholder to that. And this is going to be a balance between property owners and the businesses existing and the residents behind. This will be difficult decisions, and not everybody's going to be happy with the outcome, but we're going to try to find a way to narrow to create that balance. And then we have the public at large. You know, we can't force people that are watching Seinfeld reruns and binge watching it, if that's what they want to do with their evening and come to this meeting, but they're still important. They're still citizens that they're not the property owners, they're not directly affected behind, but it's part of their community. And that's a harder engagement. If you have something negative happening, engagement will work itself out fairly naturally. Proactive thinking into the future is a little harder to engage. And, you know, how do we do that? So I've come up with a preliminary schedule. It really books you out. So you can say if it's too much or combined. I was just really drafting, how do we do this? The next step would be is use your planning commission meetings before, do a forum with the property owners, send by mail to all the property owners a notice of some questions into the forum. Maybe the setup is an issue. Rather than having it right here, we could have a pre-meeting where we have some tables and the commission can be down on the floor. It's not the intimidation. You have to come up to the mic. It's not an official public hearing kept to 2 minutes. Just depends. If 70 people show up, we'll probably say, can you not take an hour? You know, but I don't know if it has to be strictly, tell us what you think, we'll write it down, maybe we'll respond to you. I see it as more of a semi-formal place of dialogue, and you can ask questions of them. So it's a forum down. You know, being up here is intimidating for some folks. Down there, feeling like they can talk to you face to face and share, and we can dialogue and see what happens. That's kind of the thought. We would be recording. We would come in with the notepads or whatever, and if there's highlights and points, we'd make them, and so we have some type of record of what is being said, and ideas being expressed, and that's some of the thoughts and points. You know, but the goal is for them to respond to us and tell us what they're doing. You know, what are their struggles, what are their fears, what are their likes, what are their dislikes, and whether it's directly relevant or not. I don't think that's the point. The point is understand them and their needs. Then on September 26th, nearby residential. What's nearby residential? That's difficult because you know, people directly next to it, it's easy to say they're effective. You know, how far does it go? Well, rumor mill is always a great place. So the thought pattern that we discussed with our report to you is we would notice where we put some same place. It's Parish to Porter Lane, but on the residential neighborhoods, we would deliver a courtesy flyer. We did this at one point where we went and hand delivered a courtesy flyer on each door of the businesses in the past. So we would do a hand flyer to every one of the residentials or the HOAs, one block up, so to 200 East and down to 160 West. It looked like those were the clean dividing lines that we can put out all those flyers and hit the HOAs and get a substantial number of people, and then ask them in that courtesy notice to invite anybody that they think is interested, and let some of the rumor mill go out, but do it another forum, asking them questions that we've mentioned above. Then the other meeting, this is kind of precursor to saying, okay, General, this is where our thoughts are at. I don't know how well this has worked. Now, what I run on in the past is we always say 1% of everybody you notice, you're lucky to hit. So the general public at large, what do we compete with? When we did the ADUs, accessory dwelling units, we came and had some movie drawing tickets nights, and we still only ended up with 5 people. But
Corey went home with a movie ticket.
what's that?
No.
Yeah. So we've got some movie tickets purchased out of the budget and said, hey, there'll be an entering for movie tickets if you come to the meeting. We got 5 and somebody got 2 of the tickets. So good percentage on a win, but not a lot of people came out. But it was a good discussion in spite of the low numbers. It actually was a really good discussion. But this is where we invite the general public at large. This is where we're kind of tagging the courtesy notice going out in the utility billing. This is coming on the heels that you're doing another forum. But the utility billing deadline is September 24th. You won't be having the other meeting till the 25th with the residents. But they'll get it in the billings. The billings, I'm told, are the last day of the month or the first day of the month. The billings should arrive to the homes. And then you would have your public forum on October 10th. And again, set up semi-formal, record the points, gather that information if people are willing to share their thoughts to us. Then we would move to the October 24th. And is this the one where I'm trying to disappear, Cassie, the 24th? Cassie is going to graciously substitute and make up for my disappearance over across the pond to Europe. So
It's
going to be a pizza party.
yeah, it's going to be a pizza party. I haven't been outside North and South America, so this will be a new adventure for me. But that's where we will have a work session, and the work session is to provide you the data we had from the meetings and how we organized those thoughts. It would also, we've received a few online comments, so those will be included into this packet. And this is where you can sit down and pour through and say, what did we hear? And what did you hear? And try to synthesize what we heard into topics or subjects or one-line statements or whatever seems to be fit to create that synthesis. And then as you do that, the goal is to take that information and say, okay, this is what we think we heard, and begin to have those tentative places. The early tentative places is do we just lump some uses into a CUP category and test the waters for a period of time? I don't know if that's the right one, but it's an idea to approach. But this is where we're hoping you begin to synthesize, okay, here's your list that we talked about, and can we find some early ones that ought to be taken off? I'm not sure we're solving it yet, but some early ones that we know that we want to take off, some iffy ones that we might consider, and some ones that we're really leaning towards. And then we'd host this, again, repeat public hearing, the website notices, the sign postings, and say, here are our thoughts as we begin to formulate a recommendation. Here's the commission's thoughts, and give us the feedback on if we're missing something that we didn't hear. And then, November 14th, that is your only meeting that month. Due to the Thanksgiving week holiday, you don't hold your fourth Wednesday meeting. So the next meeting, if you didn't formulate it by the 14th, would be December. I don't think that's a bad thing. I'm just think of the 14th, there's one meeting. December, there's one meeting. And so we'd hit those time frames of your one meeting months to get to a recommendation. if possible. So that books you a little bit.
I think it's good.
I'm
Really?
supportive
I like
of
it.
the timeline.
I like it. Looks really good.
I would like to make one suggestion though, Corey.
Sure.
I've heard that there are some concerns in the community that what we're addressing is going to create a more intense commercial use along Main Street, and that's feeding into some concerns that it's going to lead to that we're looking at making higher density along Main Street. That's obviously not
Right.
what we're looking to do, and I don't know where. I mean, I'm not sure based on what evidence that we've looked at is driving that concern, but it is a concern, and that at least that I'm hearing. And I want to make sure that when people are coming and providing comments, that they're providing comments based on what we're actually looking at and what
So
actually
we
is.
can craft
It-
the expectation.
And what I'm wondering is if we could, I mean, you put together, it's 10 pages of information in our last August 8th packet that I thought was really concise, that explained very clearly that what we're looking to do is it's still going to be a commercial medium zone. It's still going to be limited, the buildings, to 10,000 square feet, that they're still going to be limited to the current height restrictions. I thought that all of that was very helpful, and it's only 10 pages. So it's a super easy thing that somebody could just read and get their mind around. And I'm wondering if, in the October 10th meeting, you proposed putting a notice to a website link to all of that collected information. And I'm wondering if we couldn't, prior to that point, in the notices that we're sending out or on the website somewhere, kind of draw that out and point people that are going to the website or seeing the notices to that specific piece of information, because I think that that's the piece that is going to be most helpful for people to look at. And before people start panicking
Right.
about more, more intense commercial uses and higher density, it would help if they could actually see what we're looking at. I mean, I assume that the city council members who are being contacted about this will help set the record straight. I mean, I'm assuming that that's happening, but if there is anything that we can do on our end to help make sure that we're getting comments on what's actually before us, I think that would be helpful.
Yeah, and I think that's a good point, and I think we would coordinate with you as we do create those courtesy notices and everything to have that directive. Yeah, I've heard the same thing, so the feedback's coming around, more intensity and intensity versus density, and they're all lumped in the general public realm, they're all lumped together, and the exact same feeling is that you're urbanizing or you're intensifying the conflicts that may happen, and the density is always somehow rooted in there from the overlay, the past of the overlay. So, yeah, I think we could try to put some clarifying comments in that.
I love that the public is participating. I think
Well,
it's
the benefit
great.
of the rumor mill is it generates anxiety, and when you generate anxiety, it sounds bad, but it drives some grassroots participation, and it's difficult to get past that. That's in
Right.
these forums, it's hard to get past that. But if you can, in the past, what we've done when in other cities that I've done when we have had a hot button topic, the strategic thing is just give people 15 minutes to say whatever they want, or put it on a card and just say whatever is on your mind, put it on this card. So, because that's what they came to the meeting to do. And if we can get them to just put their, whatever is on your mind, whatever is concerning you, whatever is eating you, write it down and give it to us. Because then they can relax a little bit and say, I said my thing that I've been thinking about for the 3 hours, and now I'm nervous and my heart beating because I'm coming to this official meeting and I'm feeling scared. And sometimes they even say things with influxes that they didn't intend. And so if we can get them to write it down, they'll relax and they can start participating in the discussion.
Yeah, my intent would be, I would hate to see people come and say, no, we don't want to do any of this, because their concern is that this is a density issue, not realizing that there are things on our list like we want to open it up for parks or for single-family housing, right? And people just push back and say, whoa, but I've heard that this is really bad. I mean,
Or
I
the
think,
dead center of town.
or, by the way, the notes, I know we're going to get to the meeting minutes, but the way that you did that, Avalon, was genius. So I think that there are absolutely valid things to debate on the lists that we're, on the specific list that we're looking at, for sure. But I would like to see, it would be more helpful for us, and I think for the city council, for people coming and actually debating those specific issues.
Yes.
And not just coming and freaking out that, you know, we're trying to create more intense commercial use along Main
Right.
Street. Because I don't think that that's the purpose.
Right.
Well,
Yeah.
and to strengthen that argument, if 84% of landowners are local, we might as well, before we meet with the landowners, we might as well ease their concerns too, because then if they're local, they will let people know as well, since they're the first people that we're going to be meeting with.
Right, right.
Let's just get that up front really quickly to them.
Good point.
Yeah, but I like the agenda that you've set out. I think that it makes sense. I think that it allows for a lot of opportunities for the public to participate and to give us that feedback. And I feel cautiously optimistic that I think that we'll be ready to make the recommendation by November 14th. So, does anyone have any concerns with that agenda schedule?
I could see it going a little quicker personally, but I recognize it's there to slow things down.
I will say, I am currently in a show at Centerpoint, and so I won't be available on the September forums. I may be able to come to the 26th, but the 12th I'm not available. But the rest I am.
Great. What show are you in?
Ragtime.
Yay. Good, I'll have
Well,
to get tickets.
We will always still send you all the
Yes,
information and
please
everything
do.
like regular. so-
Please still, but I'm just saying I will be unavailable to attend
Yeah.
on the 12th.
Fantastic. Thank you, Corey, for putting that together and for the thought and effort behind putting together that schedule. I think that it makes a lot of sense.
Well, good credit goes to Cassie in the debate and discussion on how we try to wrap our mind around this.
Fantastic. Hopefully that discussion was helpful for our member in the audience. Have we gotten any additional people online, or is it still just us?
Cassie's received a few. Online.
Online.
here. I was thinking comments. Let's go to the dashboard. One.
I always tell my husband that he can come on to watch me, and he never does. I don't get it.
Well, when Corey said, you know, the people that watch Seinfeld reruns every day, I was like,
That's
oh,
you.
that's my husband.
My husband.
Or Arrested Development. I'm willing to upgrade to Arrested Development.
Day. Like, really?
All right. Thank you so much, Corey. And Cassie. Thanks to you both. Moving on to the next item on our agenda is, let's see, do we not have a community development director's report this week? No?
Oh, well.
Normally we do that before minutes. I'm not seeing it on our
Yeah.
agenda.
Well, we do have applications for your next meeting.
You want to give us a heads up?
Five.
We'll see.
Maybe.
There's a few pending.
Yeah, you got the tabled murals issue. I think the fire department is coming back. You have a fence height increase for a commercial project. Trying to remember the board in my memory.
Renegade.
Yeah, Renegade is the fence height,
Oak Ridge, probably not.
and not Oak Ridge.
Legacy Commons.
Legacy Commons, that's correct. Legacy Commons is coming in with a final site plan, so it'll be a pretty full agenda depending on if one application or another doesn't make it.
Okay. We'll watch for that. Thanks, Corey. And moving to the last item on our agenda, we'll be reviewing the minutes from our last Planning Commission meeting on August 8th. So for the public's benefit, this is the opportunity that we have as a Planning Commission to go through and review our meeting minutes from the last meeting that we have. So we typically go through these page by page. So we'll go ahead and do the same thing here. If you have any comments or want to make any changes, let me know. So let's start with page 1. Page 2.
I have one thing on page 2, line 37 toward the end. I'm pretty sure that I probably did say fails, but fails is such a harsh word. That's just a killer word. So I would like to change that to the nail salon if it does not continue as a going concern and how it would be incorporated into the development. Just kind of softens the whole thing.
Maybe going concern, I'm confused by that. I don't like that wording.
then
It's a
I
little
can go-
old-fashioned.
Yeah, it's a business term. It's an old-fashioned business
It's
term?
an old-fashioned business term.
Well,
That's why I
What
didn't
if you just leave
understand
it if it does not continue to do business?
Yeah.
if it does not continue,
To do business.
okay, fine, I'll go with that. If it does not continue to do business and how it would be incorporated into the development.
Does not succeed.
Thanks.
Okay.
Just so that it doesn't say fails. Fails is hard. That's it.
We're sensitive here as a planning
Thanks.
commission. All right, any other comments on page 2? Page 3. Page 4. Page 5. Page 6. Page 7.
I have two things on page 7. Starting on line 19, kind of toward the end of that line, he said people are really confused about why people can't be served. Can we change the second people to, and I generally hate this word, but they.
Yeah.
He said people are really confused about why they can't be served food from cup up. So we're not peopling. And then the other one is toward the bottom of this page. There's several of them starting on line 47 and Fidel. It's Fadel. And so there's 2 on line 47 and 1 on line 52 that refer to Ms. Fidel, but it should be Fadel.
Great.
Was it Kim Samuelson also?
Oh, Kim Samuelson.
Kim with a K-I-M.
I missed that one.
Cassie saw it.
Any other revisions on page 7? Page 8. I would like to draw specific attention to line 3. He also joked that he believes a cemetery or a mortuary should go on Main Street so they could be the dead center of town. But that was great. Any other comments on page 8?
That is a quote that,
That is a quote.
that's a golden nugget quote during
love
the
it.
meeting. That's awesome.
Okay, more comments on page 8?
No.
Page 9. The chair will entertain a motion.
Chair, I hereby make a motion to accept the minutes as amended and establish an official planning commission declaration that Avalon may be the greatest minutes provider in the history of Davis County. With findings, the number of grammatical corrections we've done during her tenure.
I second that motion.
The motion has been moved and seconded to approve the minutes as amended with the accolades provided to Avalon. Any further discussion or debate? All those in favor?
Aye.
Any opposed? All right, and the minutes now will pass and go into the official city record as amended, as soon as I sign them. So, that's it on our agenda. So I will entertain a motion to adjourn.
Second.
Okay.
We need a motion.
I was actually trying to let somebody, okay, I will just move that we adjourn.
Second.
All right, all those in favor?
Aye.
Aye.